Welcome to the first lecture on legal reasoning. Now we will consider the topic of reasoning from sources. I want to begin by highlighting something that is strange about law. It is not strange at first sight. It's only strange when you really stop to think about it. Normally, to act rationally is to act with a view to achieving the best possible outcome. This is something that is taken for granted in economics, psychology, and much of philosophy. It's also sort of part of normal life. You say, I act rationally because I'm trying to get things right, to get the most good things I can. In this, it does not matter if we're talking about individuals, groups, or institutions. They are all classed as rational insofar they look into the future and act in such a way to make things as good as they can be. Law does not make decisions by looking into the future, not primarily. Law rather looks at the past. It looks into the rules that have been laid down beforehand, and takes decisions accordingly. To act rationally within the law is not to calculate expected outcomes, but to act according to the relevant rules. I will complicate this picture later, but for now, let's get started like this. Naturally, law is about deciding in accordance to the law that is written down somewhere. This is something that should be expected, but upon a scrutiny, it seems not to make much sense, and it's certainly strange that such a form of decision should be so widespread and successful, even if it's somewhat less successful today than 200 years ago. We can ask ourselves, why not do things differently? Why not assign social problems to committees of experts, psychologists, economists, maybe neuroscientists, to give us suggestions about how to solve them? I can tell you that that would not be a good idea, but it's rather hard to understand why. Unless we grasp this basic orientation of the law as a starting point, certain forms of legal reasoning will appear inexplicable. For example, consider the vast amount of energy that lawyers put in fighting over words. Why do this? Why not fight about the expected consequences of making this or that decision? Why fight so hard about whether the word freedom means this or this other thing? This, of course, is totally expected, for law is about following the laws. That's what it is. But it's still a strange orientation of law, an orientation towards the past that will serve as our entry point into the discipline of legal reasoning. I have just said that the practice of law, of making decisions in accordance with rules that have been laid down in the past, is our entry point into legal reasoning. Just by taking this entry point, I can already introduce the judgment of legal validity. The judgment of legal validity is the mental operation that is most characteristic of legal analysis. A judgment of legal validity is the assessment of whether some act, practice, or institution is within the relevant laws or not. The judgment of legal validity can be sharply distinguished from other sorts of judgments that are common in social life. For example, we can also judge the effectiveness or the morality of something. But this is in principle very different and very distinguishable from the judgment of validity. So imagine I ride my bike at night without lights. This may be effective. I might have very good vision, and it might also be moral, for example, because it creates no risk for others. Well, it might, but let's say it doesn't. But legally, it's quite simple to find that it's not valid. Or I may want to terminate my rental contract before the expiration date. This may be effective in the sense of allowing me to better pursue my aims. For example, that somehow will help me go on vacation. It may even be moral, for example, if I discover that the person renting in my apartment is a researcher trying to find ways to make tobacco more addictive. But legally, it's quite simple to find that this is not legally valid, and that's a different sort of assessment. So let's go back a little bit to what we first mentioned about deciding on basis of rules set in the past. How does a form of rationality defined in this manner, on the basis of antecedent rules, even get off the ground? What has enough power to distract us from our consuming concern with the future and effective action? The answer here is authority, autoritas in Latin. Still today, this word feels like it weighs a ton. The practice of law operates against the background of authority. Now, authority is a notoriously difficult concept to work with. It may be defined as the right to be obeyed. Notice that this concept is in itself juridical, a right to be obeyed. It's a right. This is a good sign. The fact that authority and law are difficult or impossible to define in non-legal terms suggests that these concepts are intrinsically linked. Here we may have a bit of a circular definition, but not all circular definitions are undesirable. Some are unavoidable. Now, who has the right to be obeyed? Commonly, rights of this sort were attributed to kings, and today most people believe that the democratic process or the people acting in a democratic manner have this sort of authority. Authority does not need to be attributed to a definite person. Custom, as the practice of a group extending through time, may be one of the most primitive and fundamental types of authority. Okay, but what if you do not believe that the king, democracy, or custom have authority? What if you are a philosophical anarchist of sorts? What is the law to you then? Well, this is the crucial part. This is quite crucial. The answer is that it's the same. It's the same then for a loyal citizen, only that for the anarchist, the relationship with the law is a little bit colder. The authority that the law is interested in is not philosophical or psychological. It is social. What matters for law is that the authority setting up the law exists because sufficient people believe it exists. Whether it really exists, whether it really deserves adherence, that is a separate question. Whether you personally believe in the authority of the law or not is simply irrelevant. This is why it's perfectly possible to be an anarchist and a lawyer, as per the example of Hans Kelsen. Consider now these two expressions. Expression number 1. The law of the Netherlands has authority, and according to it, you have to pay your taxes on April 15. Or it does not have authority, and then you don't have to pay them. Now expression number 2. Assuming the authority of the law of the Netherlands, a matter which I'm happy to bracket, but let's assume it for the purpose of this legal analysis, you have to pay your taxes on April 15. In its normal operations, legal reasoning always functions in the latter manner, as a statement number 2. Using this form of reasoning, our anarchist lawyer can put himself in the shoes of normal legal subjects, use the law and draw right conclusions from it, even if it deeply rejects the law as a matter of principle. The existence of legal authority, then, is social, not individual or psychological. In this manner, law is like money. You may not believe in money. You may think that it's just some sort of fantasy, that it would be better if it didn't exist, but enough people believe in it, and that's enough for it to have significant consequences. Now, in saying this, I must be understood very carefully. I am not saying that legal authority is an illusion. That may depend on time and place. I'm only saying that this question, this ultimate question, is not immediately one that matters for legal analysis. Now we're in a good position to talk about the sources of law. Sources of law are quite simply the form in which whatever authority the law presupposes to exist expresses itself. It is the mechanisms through which law is laid down. So, for example, the authoritative power of a king may be expressed through royal edicts, which would then be the sources of law for that kingdom. The democratic government of the Netherlands expresses its authoritative will through the acts of Parliament, which are then the sources of law. The common law, in common law jurisdictions, I will say a little bit more about them later, the authority of the common law is expressed through judicial decisions, which are sources of law. Because law is, at least in part, a practice of deciding in accordance with the relevant rules, it is the practice of deciding within the boundaries of the sources of law. To get started in legal reasoning, one must locate the relevant sources of law, and that is where it all begins. In reading legal text, you will hear much about the sources of law and virtually nothing about authority. That is all right. The introduction of the concept of authority at the beginning aims to make the practice of law of always relating back to sources comprehensible, understandable. Afterwards, it can be ignored, at least until really polemical cases show up. That is when we will need that concept once more. Now it's possible to differentiate between common law and civil law. So these two big legal traditions that pretty much cover all of the world. The reason that we can do it now is that what sets these two legal traditions apart at the most basic level is what they recognize as a source of law. The civil law recognizes only legislation, that is, only acts of Parliament, as a source of law. The common law recognizes legislation and the so-called common law, from where the common law system gets its name, as a source of law. This term, common law, refers to the decisions of judges and especially their accumulation through time. When a judge makes a decision in a civil law jurisdiction, this decision is binding only to the litigants. It is not a source of law for society in the general, in the sense that we have explained thus far. When a judge makes a decision in a common law jurisdiction, this decision creates a precedent binding for future cases with other different litigants. Future cases must be decided in accordance with the prior decision, and so it is a source of law for society in general. It may be perplexing to think that common law lawyers must deal with thousands and thousands of cases. How this works will be explained later. Among the rules that an authority can create are rules empowering other authorities to make yet more rules. So, for example, the legislator may empower the municipality to make rules about garbage disposal. The municipality, in turn, may empower a neighborhood council to decide on which day will the recycled paper be collected. These sources will naturally be ordered in a hierarchical manner. And then it will be necessary that the sources lower down in the hierarchy conform to the standards set by the higher sources. So, for example, if the neighborhood council decides to take out garbage every day instead of simply picking one day for the truck to come by, or if it decides not to take the garbage out at all, they will be exceeding the limits of their powers. As a consequence, their decision will be rendered invalid by the operation of rules higher up in the hierarchy. And this means that the judgment of validity that we introduced very early in this lecture can be done in layers, can operate in layers. We can ask whether some act is in accordance with Rule 1, but we can also ask if Rule 1 is in accordance with Rule 2, and whether Rule 2 is in accordance with Rule 3, and so on. So that adds a layer of complexity to legal analysis, which we will cover hopefully a little bit later.